the stuff that nobody ever thinks about because this is not exciting and it never makes it on TV.
Yeah.
So if you actually get through your trial management conference and you do not have any other issues, you've been able to resolve on consent, you've got everything kind of formed up and planned for how long your trial is going to take, what your case is going to be about, who your witnesses are, what the documents are that are going to be introduced.
Yeah.
Then the next stage is the trial.
Oh.
The last data that I have seen, and it's granted it's a couple of years now, but since I know if it's been updated or not, but the last that I'd heard is that less than 10% of all family law cases in Ontario actually ever end up going to trial.
Right.
So that means, looking at it the other way, about 90% of family law cases in Ontario get settled without having to go to trial, because going to trial is risky. That's where you stake out your position in the sand. You put your case before the judge, the other side puts their case before the judge. Based on the evidence and the testimony and the documentation that's filed, the judge will then make his or her decision. Sometimes one party will be really, really happy with the judge's decision, and the other party will be really, really not happy. More often than not, at the end of a trial, the normal situation is neither party is actually really happy with what the judge did, because neither of them got exactly what they wanted. But that's the crapshoot, the risk you're taking when you go to court. You're putting your lives in the hands of a third party who's a very experienced judge dealing with these issues. But you have no control over what that judge is going to do with the information evidence. The judge is bound by rules and precedents and has to really consider what he or she hears. But a judge's decision is a judge's decision. You don't get a do-over. The only thing you can do at the end of a trial, if you're not happy with the result, is you can't say, well, I want to appeal that judge's decision. But you can't appeal a decision just because you don't like it. There has to be a reason why you think that decision should be appealed. Either the judge made a mistake in fact, or made a mistake in law, or did something wrong through the process of the court. And it is very time consuming and expensive and technical to try to overturn a judge's decision by way of an appeal. It is done very infrequently. And I think you and I actually did a video on appeals in the wild and woolly world, where they go, because depending on what the issue was and what was decided and what level of court it was decided at, your appeal is completely different. You don't always go to the same court when you're looking at appealing a family law decision. So very technical, very complex, and very difficult for sore losers to deal with. There are matters that go on appeal, and a judge's trial order will be overturned. But again, usually what happens if a trial decision is overturned on appeal, more often than not, whatever the appeal decision is, it'll send the matter back down to the lower court to be done again.
Oh gosh.
Sometimes the appeal court will substitute their decision for the trial judge's decision. But that's more unusual than saying, nope, we think the judge did make a mistake. You're right. You're going to go back and do a do-over, because you can do a do-over when the appellate court tells you can do a do-over.
I see.
And as I said, sometimes the appellate court will just say, well, we're not going to make you do a do-over. We're going to substitute our decision for the judge's decision. But again, you don't know until the appeal is heard which way the appeal court. Okay, so I don't want to get into a lot of detail about walking through what happens at a trial. For starters, if you're in a family law trial in Ontario, for goodness sake, don't figure out how to conduct a trial by watching American TV. Just don't go there. There are even again because there are a lot of people that are going through trial that are self-represented. And there are guides on both the superior court level and the provincial court level on trial guides for self-represented litigants to help self-represented litigants prepare for going to trial, because you don't get a freebie on not following the rules of evidence and the other court stuff just because you don't have a lawyer. If you are going to self-represent, you will be held to the same rules and expected to do the same things and not do the same things as you would be expected to do if you were a lawyer acting on behalf of your client. So ignorance of the law is no excuse. You're
Right.
not going to be allowed to do something or ask for something that a lawyer acting for you would not be allowed to do because the rules do not allow it, or the legislation for under what you're claiming don't allow it.
Mhm.
So that's the end of the trial.